constitutional borrowing, and then we looked at the question of rights and the idea of judicial legitimacy. And when we announced the beginning of Module 2, we also said that the module will flow with both of them together, because you can't really separate out the question of rights from the question of the legitimacy of the judiciary, because they're going together. So when we did this discussion on the directives and we did this discussion on the role of the judiciary, we were doing it in the context of the expansion of judicial review that has happened because of the question of rights. We might not kind of look at each individual right, but we would want you to read them together. So yesterday night I had some queries about the fact that we hadn't done these directives in great detail, and so were you expected to comment on them? I would say yes, because it's not like we can touch upon every one of them, and we're only trying to give you a manner in which you read those together. To take an example, although yesterday's evening discussion was largely around the moral right to die, but the fundamental questions that we were trying to draw your attention to were, for example, does the judiciary even have a role in questions like this, which are largely, as some would believe, beyond reason, or some would believe are matters of policy or something that the legislature should take care of and not that judiciary should get into at all. So it is a question that's framed in the context of the limitations on judicial review. It is also framed in the context of how does one identify values in a constitution. So when we speak about certain constitutions where you have certain explicit values belonging to particular religious faiths written into the constitution, do you say then that the constitutional interpretation hinges around those values which are explicit in that constitution? Or are these questions really which are beyond any particular constitution, because the question of the value of life, even if it is recognized in different manners in different constitutions and in different cultures, but it is more or less the same idea that evolves not in any particular country but which will evolve in a universal way. So the question that is really important for us there, notwithstanding the kind of debates we had, were that if you want to, so the first question is, should judges take a decision on it? Is this a matter of an individual right, or is this a matter that would be so intrinsically linked to a larger political idea that the courts ought not to enter into it? Or would it be, and if you decide that no, the courts have the power to answer this question, on what basis should they be answering the question? Does it revolve around interpreting a positive or a negative right? So when you're interpreting the right to life, are you really interpreting the right to life or the right to die? And should you say the right to die is an integral part? So when we talk about enumerated rights, and when we're talking about rights which would need the recognition of other rights for that right to be meaningful. So if you don't recognize the peripheral rights, then the right itself does not have any value. So if you don't recognize dignity or autonomy or choice and the value of life, then you're not really recognizing life, because then life gets reduced to, as somebody was putting it, just the heart beating or the blood pumping through your veins. I mean, are we really looking at life in that manner, or we really should be looking at life in terms of the other rights which need to be recognized to make that more meaningful? So is it an interpretation of a positive right, or is it an interpretation of a negative right? And in this process of interpreting something as a positive right, are you then going to be looking at other constitutional rights and the manner in which you have interpreted other rights? So does the interpretation of the right to life hinge on how you have interpreted, let us say, freedom of speech and expression or religious freedoms? Does it hinge on those? Or does it, and the examples that we gave you, both the Indian Constitution and the Irish Constitution, were judgments which used a comparative analysis to arrive at a decision. So Aruna Shanbag was referring to British cases, and the Irish Constitution were referring to a different set of cases. So when we are doing this, is this necessarily something that is inevitable, that it is, you cannot escape trying to see how courts, even if the value system might or might not be different in those countries, should you really be pitching it on the value systems of those countries, or should you be talking about this necessarily being a universal right and hence applicable across the board in different jurisdictions, notwithstanding what the value systems of those countries are. And this would then apply to, let us say, questions of child rights in the same manner. I mean, I'm not saying in identical manner, but I'm saying the same questions arise. When children are not explicitly recognized in some constitutions, whereas other constitutions explicitly recognize the idea of the family and the idea of children, and the best interests of children are written into the Constitution, is that a reason why there is an understanding of child rights, or do we continue to have the understanding of rights of children irrespective of whether or not they're specifically mentioned in the Constitution? Now, how does this happen? Are we looking at child rights similarly to we looking at the other rights in the Constitution, or are we saying each of these needs its own space and hence ought not to be compared with other rights? So, to my mind, all of these questions are common to any right that you want to pick up, any question of judicial legitimacy, any question of identity of the Constitution, and any question of the values of the Constitution or the spirit of the Constitution. So, the fundamental questions we had laid down right in the beginning, and these are all instances where those questions play out. And we would want you to look at all of them in this manner. The three instances that we picked up happen to be directives, happen to be life, liberty, and the rights of children, but it's only incidental. We use these as examples to illustrate a larger problem. And today, in today's sessions, we're trying to come back to where we started, which is that of the role of the judiciary within the organization of the Constitution, and how does one understand its role. And in the following lecture, we will look at this particular role across constitutions and see what kind of lessons we have, and we'll move towards our conclusion. The idea of leaving open time for questions is also that you would raise these questions. So in the time we had yesterday on rights, you were free to raise questions of directives, you were free to raise questions of land, you were free to raise questions of children. It so happened that the discussion all happened around one particular right, but that is really something that is in your hands. So if you want the other things to come on board, then you would need to be party to putting them on board there, okay? So with this introduction, I now request Justice McMillan to give his lecture.
So, good morning and congratulations to all of you for being here so early in the morning. We're on the last lap of our voyage of discovery. Today we're going to deal with quite a critical subject in our first session, and I'm afraid I'm going to treat it in a rather depressing way. In the one sense, we're going to talk about the separation of powers, and that, of course, is connected with the fundamental issue of the rule of law. So what I'm going to do first is discuss the rule of law, and then we come on to instances of the separation of powers, which principle is the keystone of the rule of law. The context for all this is, to my mind, very important. And I want to start with an organization in the United States called Freedom House. Freedom House does surveys, and it's a watchdog for human rights worldwide. It was founded by the two main political parties in the United States, the Democrats and the Republicans. Yeah. So every year it issues a report, and last year the report said in 2016 populist and nationalist political forces made astounding gains in democratic states. I'll just repeat that, astounding gains in democratic states, while authoritarian powers engaged in brazen acts of aggression and grave atrocities went unanswered in war zones across 2 continents. So we're looking at a situation worldwide where what this report dealt with was incursions into democracy from within democracies. And the report went on to say that a total of 67 countries suffered net declines in political rights and civil liberties in 2016, compared to 36 countries that registered gains, and that this marked the 11th consecutive year when declines outnumbered improvements. But what caused Freedom House the greatest concern was that in past years the decline in freedoms had taken place in non-democracies, in dictatorships. But in 2016, what caused the greatest concern was that these deteriorations were taking place within democracies. And in Europe, they identified a large number of countries where these problems were becoming manifest. So I'm not talking about countries like Syria, Eritrea, North Korea, or Uzbekistan. I'm not talking about terrorism or crime or corruption, all of which are obvious threats to the rule of law and the separation of powers. I'm not even talking about politicizing judiciaries by asking judges to address socio-economic issues, but that's where we'll end up. What seems to be the problem, and this relates directly back to the Indian Constitution, is that there is a challenge to the comfortable political consensus which judges, lawyers, academics, media people all adhered to and subscribed to for about 60 to 70 years. And that consensus was that you could look at the rule of law as being the apex, and that there was an inevitable progression, that by force of reason states would gradually work their way towards democracy and the rule of law. And that was a comfortable assumption. It was something that in Europe gained great currency, even in the up to 1990s, when so many countries joined the European Union subsequent to the fall of the Berlin Wall. But the concern is that democracy doesn't always self-validate. It doesn't always strike roots so deep that it cannot be removed. And when I was young, I studied a book when I was studying history called The Strange Death of Liberal England. And I just wonder whether, I hope, in 20 or 30 years' time, that people will not be talking about the strange death of liberal democracy. So, let me tell you about a survey that was done by 2 reputable scholars, which was done for what is called the World Values Survey during the period 1995 to 2014. It showed that in Europe, 52% of citizens among the generation born in the 1930s believed that to live in a democratic country was fundamental, but only 45% of those born in the 1980s shared that view. In the United States, 72% of those born in the 1930s believed that democracy was essential, whereas a startling 30% of those born in the 1980s shared that view. And that survey was done in 2014, and if anyone had been looking for a precursor to the rise of populism in the United States, if they had looked carefully at that survey, they would have seen a pretty fair indication. What had happened was there was a loss of faith in institutions, and that loss of faith in institutions was predicated on the fact that the institutions were simply not seen as supporting ordinary people. The liberal middle class, who espoused values which were ostensibly supportive of working people, were still espousing those views, but the working people, too many working people, were alienated from society, and alienated because of the fact that there was no work. So if we take Europe, in Spain, in France, large sections of the immigrant populations, second generation, are unemployed and alienated. So it looks as if, and the challenge for all of us is to ask ourselves the question, to what extent does this concern regarding legitimacy apply also in India? Do people put their faith in institutions because it affects their social and economic welfare, or because they believe in the institutions because they have an inherent value? For example, do people trust the courts? Do people trust politicians simply because they are institutions worthy of trust? Or do they judge the institutions by those who hold those offices and by the actions of those who hold those offices in circumstances where the job is not simply being done? So we come then, in that context, to the separation of powers. And my thesis is that this is absolutely a critical issue. And I'm just going to deal with a little bit of history. I know it sounds very arcane, very distant, but it's relevant. The concept of separation of powers derives from an 18th century French thinker called Montesquieu, Montesquieu. And as we all know, talking again about ideas migrating, these ideas migrated across the Atlantic to the United States, where they found a home in the United States Constitution, thanks to the work of Madison and Jefferson and the other framers of the United States Constitution. And ultimately, the idea migrated back here in 1946, 1947, as a result of the studies of the constitutions of Canada, of the United States, of Ireland, and Australia by Sir Benegal Rao. But what's significant is that while other countries specifically put the idea of separation of powers into their constitution, that did not happen in the Indian constitution. And as we know, the framers of the Indian constitution analyzed in great depth and with great seriousness the various provisions of the other constitutions which were most relevant to them. There was a conscious rejection of the idea of separation of powers because I think Nehru, Ambedkar, felt that it would be more useful to have a degree of overlap. But the question I want to ask is whether, and it's a matter for not for me to answer, but whether there is a reasonable apprehension that perhaps was a wrong turning, and that perhaps a clearer line of distinction and delineation between the powers of government might have been a better move? I think that's a question for Indians to answer, not for an Irish person. So we followed the idea migrated back over to Europe after the Second World War. And I want to deal with another disturbing notion. The idea of separation of powers derives from a particular time in a particular place. It arose in what was called in Europe the Age of Reason. And that Age of Reason was a time when people could engage in, although a very small elite group, could deal with these issues within a framework of debate where there was room for reasonable disagreement. These are people who approached issues on the basis of reasoned argument and wrote arguments pro and contra the structure which was envisaged for the United States. And the fundamental thing that they wished to achieve is to obtain a balance in society. They wanted to ensure that there would be the law would provide a check against what de Tocqueville called the tyranny of the majority. And the separation of powers is the most important thing in ensuring that there is no tyranny of the majority and ensuring that the three parts of the triangle actually operate as checks, one against the other. One of those checks would be the judiciary. And the judiciary was to function in such a manner as to ensure that its reasoning, in other words, the reasons it could give for its judgments, could be transparent and could be understood. Because that is an inevitable part, a necessary part of the rule of law. And these ideas struck home, but what I wonder now is whether we have a difficulty in India with the way in which the various powers identified in that triangle operate. So if we look at the United States, which is the archetype, the paradigm, you'll see the three parts of the triangle: the president, judiciary, legislature. Each one of them checking and balancing against the other. Each one at the moment being tested more than has happened for many years. You will recollect there have been attacks on the judiciary. You will recollect that there have been attacks also, even on the legislature. And you will recollect also that there have been attacks on the media. So when we come to the United States and we look at the paradigm there, we have to ask ourselves the question: can those lines of demarcation now conveniently be drawn in India? Nice, neat lines in circumstances where, for example, the United States Supreme Court will not deal with issues, particular kind of issues, because they consider it a, inverted commas, political question. And they do not deal with matters where political questions arise because they consider such determinations are matters for the legislature, the democratically elected legislature. Is the same true in India, I wonder? And if we look at the way in which the tripartite balance operates in Ireland, you will see, if you look at the same triangle, very similar. The executive, judiciary, legislature. The executive determines policy. The legislature enacts legislation. The judiciary interprets and applies legislation. But the judiciary doesn't try to carry out incursions into the legislative function. It doesn't try and determine what government policy should be. And the furthest it will go is to stop short and indicate where there is an unconstitutionality, perhaps indicating general lines where the government might intervene or legislate. So if you look at those two triangles, you'll see that there is an equal balance between the three. And if we go to the third triangle, that of India, and we have in India, we just go back out of that. Wait for it. There's India. Now, at the end, what I think we need to discuss is, how do you think the balance works there? Do you think it's a tripartite balance, fairly even powers between the three? Or do you think that there's one or other of the three powers has more power than the others? Do you think that the issue of legislation solely lies with the legislature? Or do you think that perhaps a different situation arises? And if a different situation does arise, if, for example, hypothetically you come to the conclusion that the judiciary is rather active, as people say it is, well, then there's another question. Why is that? And I'd be very interested in hearing your answers. So, another concern I have, we leave the slides for a moment, but another concern I have regarding the separation of powers is a functional one. What the separation of powers doctrine does is it demonstrates there is accountability. It demonstrates there is government under law. It demonstrates that there is legislation and law in a country where the legislation is clear, public, identifiable, and in a state where the liberty of persons is guaranteed, including freedom of speech. And it's one where the state provides institutions whereby laws are enacted and administered in an accessible and effective way. And the question I ask is whether all laws in all democratic states are enacted, passed, or put in place in an effective way. So, in order to achieve the proper paradigm of the triangle, obviously you need properly resourced courts. You need to ensure that your courts are able to provide effective justice in a speedy way. And you also need to ensure that the institutions which you have within a state enjoy trust or legitimacy. And what it seems, speaking as an Irish person and a European, my experience over the last 15, 16 years as a judge demonstrates to me how quite fragile the rule of law can be, and how fragile the rule of law can be in situations where apparently it had struck deep roots. And I've already given you the examples of Poland and Hungary. Hungary, a country where in 2010 there was elected an illiberal democracy, self-confessed, built a fence between Hungary and Serbia, victimized and made victims of any migrants, rejected the idea of the rule of law, refused to follow the directions of the European Union regarding preserving the independence of the judiciary, brought in a new judiciary, brought in a new retirement age, as I've mentioned, so that judges were to retire at the age of 62. Pretty easy to do. All you need to do is to pass legislation. You don't even have to enact a constitutional amendment that way. And that's what's called the Tactic of Legality. The Tactic of Legality is what Hitler used in the 1930s because every measure he took had the veneer or the appearance of legality, passed through the Reichstag. I'll just tell a short story about myself. In 1989, a group of us went on a trip to Russia at a time when it was still Russia, USSR. And we were talking to a group of Russian lawyers, engaging in common experiences. But what was most striking was, when I was there, the extent to which there was absolutely no faith in the ideas of institutional democracy. At the time in 1989, Mr. Yeltsin was seeking to introduce democracy. Mr. Gorbachev had been there before seeking to introduce democracy. And when I spoke to the lawyers, and these were lawyers who were liberal inclined, they said the people actually were much more interested in being able to ensure there was food. And you could understand that, because when I was there was a queue. I saw a queue, and I asked what was the queue for. 46 people in the street queuing to buy one egg each. And you could see that there had been a total collapse of the way in which society should operate. But there were a lot of people making a lot of money because capitalism had come into Russia, but no institutions to check the balance, no institutions to prevent the monopolists becoming immensely wealthy and becoming the oligarchs which we know about today. And what was striking was that if you scratched the surface and you went behind the shops, the shop fronts, you could go into a shop and there were 2 items for sale, and then they'd open a door, and you went behind where there was everything you could possibly buy on the black market, provided you could pay the right price. But for the poor or the dispossessed, they couldn't pay the right price. They were trading. So what's the moral of the story? Well, democracy didn't do very well there because there was no tradition of democracy. And when it was introduced, nobody bought into it, and what they did buy into was capitalism, state capitalism, and capitalism on the part of the oligarchs who were able to engage in gathering together capital, using capital, and thereafter acquiring monopolies. So let's go back now and have a look at some case law, because what I want to do is just illustrate from my own country, which I think in many ways may be the antithesis of the Indian situation, how the separation of powers is observed there. I want to emphasize I'm not making a judgment, because I recognize that every test must be contextual. I recognize that separation of powers is one which it may be seen, and was seen, I think, in the Constituent Assembly as overly rigid, and one which would mean that the needs of the people might not have been properly satisfied. So if we just look at one case called Buckley, in 1950, where the Supreme Court had to, I'll just put the context, the Supreme Court had to deal with the situation where a fund had been established to take in monies which were left over from a political party, the Sinn Féin, which by then had become defunct. There was litigation about it. In other words, a case had been brought before the courts seeking a declaration as to what was to be done with the monies. But to preempt this, the government introduced legislation seeking to set up a board which would take hold of the money and administer the fund. And the Supreme Court, in a judgment which fired the shots to demonstrate to the executive that this was not something that was tolerable, indicated that having dealt with the question of private property, which was one of the grounds, went on to deal with the question of separation of powers. So you see what Mr. Justice O'Byrne said there. There is another ground in which, in our view, the Act contravenes the Constitution. We've already referred to the distribution of powers affected by the article. The effect of that article and Articles 34 to 37 inclusive is to vest in the courts the exclusive right to determine justiciable controversies between citizens or between a citizen or citizens, as the case may be, and the state. In bringing these proceedings, the plaintiffs were exercising a constitutional right. And then he went on to say, and they were and are entitled to have the matter in dispute determined by the judicial organ of the state. The substantial effect of the Act is that the dispute is determined by the Oireachtas, which is the Irish Parliament, and the court is required and directed by the Oireachtas to dismiss the plaintiff's claim. But he said, in our opinion, this is clearly repugnant to the provisions of the Constitution as being an inappropriate interference by the Parliament with the operations of the courts in a purely judicial domain. So, very clear distinction there between what lies with the judiciary and what lies with the Parliament. And if we look at another case called TD, and I emphasize we in Ireland are at the apex of the triangle, I think, in relation to separation of powers. We're probably one of the most rigid, the distinctions are probably as rigid with us as in many other countries. Let's look at TD, which was a judge in the High Court with which I had much sympathy, directed the state to take steps to protect children who are at risk and to build an institution to provide for them and accommodate them. The judge actually threatened to imprison a minister if this was not done for contempt. So the thing went quite far. So Mr. Justice Hardiman, speaking for the Supreme Court, dealt with the matter in this way. Suppose a judge is this crystallizes. Now, Mr. Justice Hardiman, good friend of mine, we disagreed on many issues, but he was a textualist, but also a rigorous defender of the idea of separation of powers. And what he said here encapsulates many of the issues. Suppose a judge is dissatisfied with the policy of the legislature or government for the discharge of their constitutional obligations or with its implementation. Is it open to him or her to determine or approve a particular policy, make detailed orders for its execution with public money, and prohibit any change of policy without permission of the court? Let's just go back there. To determine or approve any particular policy. So then he went on to say, or is that a constitutionally impermissible invasion of the functions of the government and of its responsibility to Dáil Éireann? These are central questions at the heart of the present appeal. He went on to say, the question of whether relief of a particular kind is within the power of a court to grant, or on the other hand, to borrow a phrase of Mr. Justice Costello, as he then was in another case called O'Reilly, it is of a kind which must be sought in Leinster House, that's our legislature, and not in the forecourts, which is obviously our court building. And it involves the application of the constitutional doctrine of the separation of powers. And then he went on to say, if the judiciary, the legislature, or the executive took to themselves powers to deal with a particular issue simply on the basis that it provoked very strong feelings in the relevant organ, and that it had not, in the opinion of that organ, been adequately addressed by the other organs of government, there would be a grave danger of subversion of the constitutionally mandated separation of powers. Thus, for example, and he went on to deal with Buckley. So, those slides, I think, and then he goes on to say, the sincerity and vehemence, if you just go back to that, sincerity and vehemence was not enough. Deep feelings was not enough. Emotion was not enough. He was saying that it did not clothe, the fact that there were deep feelings didn't clothe the order of the judge with legitimacy. Nor did what is perceived to be the wholly exceptional nature of the case justify the removal from the courts of an action of which they were properly seized. So, what I think he then goes on to talk about, the concept of separation of powers is an essential part of the Constitution of virtually all democratic societies, and of the democracy envisioned by the Constitution of Ireland in particular. And then he goes on to talk about the antiquity of it, and that was explained in that judgment between what's called distributive and commutative justice. And this is a very old-fashioned terminology. Distributive means the way in which the assets and monies of the state are dealt with. Retributive means giving out punishment. He goes on to talk about his first stirrings in the 17th century, that the power to govern was not based either on hereditary principle or naked force, but on some form of consent or by contract with the persons to be governed. And he goes on to deal with Montesquieu, talks about the framers of the French Revolution constitutions and the United States Constitution, and then goes on to deal with our Constitution per Article 15.2.1. And then he goes on to deal with expenditure of public monies, saying that that issue is entrusted to our Parliament. You can read it there. And then he goes on to deal with where the executive power of the state lies, with the government. And that government is responsible to the Parliament. So he says that the articles locate the power to make laws and to appropriate public monies to particular purposes in the non-judicial arms of government. On the ordinary principles of construction, I believe that this responsibility is an exclusive one. The government is not in this respect responsible to any other person or body. And then he goes on to deal with Buckley, saying the articles not merely set forth the distribution of powers, but required that these powers should not be exercised otherwise. He goes on to deal with United States jurisprudence. Powers. The court is most vulnerable and comes nearest to illegitimacy when it deals with judge-made constitutional law having little or no cognizable roots in the language or design of the Constitution. And he says that this is painfully executed in the face, this is a quote from the United States case, this is it painfully demonstrated by the face-off between the executive and the courts in the 1930s, which resulted in the repudiation of much of the substantive gloss that the court had placed on due process. So he was quoting there from the United States authority, Bowers, and the quotation just at the end of that paragraph, otherwise the judiciary necessarily takes to itself further authority to govern the country without express constitutional authority. And then he goes on to say it's perhaps natural that much legal thinking of the separation of powers has as its primary focus the immunity of the judiciary from improper pressure or interference from other organs. And the U.S. Justice said the case brings into sharp focus the fact that the spheres of those other organs are also constitutionally mandated, and the division of powers in itself a high constitutional value directed at the preservation of the people from the accumulation of excessive power by any one organ or its members. And then he went on to say the classic statement of the distinction between the justice whose administration is provided for in Article 34, this is Mr. Justice Hardiman, and the political functions set out in O'Reilly. And then he goes on to passages cited from O'Reilly versus Limerick Corporation. And then he goes on to talk about the distribution made by, that distribution of public monies can also be made in accordance with the common good and those charged with furthering the common good. It can't be made by any individual who might claim a share in the common stock, and no independent arbitrator such as a court can adjudicate on a claim by an individual that he's been deprived of what is his due or her due. The situation is very different in the case of commutative justice, which is due to an individual from another individual from a relationship arising from their dealings can be ascertained and is due to him exclusively, and the precepts of commutative justice will enable an arbitrator such as a court to decide what is properly due, should the matter be disputed. The distinction explains why the court has jurisdiction to award damages against the state when the servant of the state for whose activity it is vicariously liable commits a wrong, and why it may not get jurisdiction in cases where the claim is for damages based on a failure to distribute adequately a portion of the community's wealth. And then he goes on to talk about the order, that this is Mr. Justice Hardiman, being constitutionally flawed because it purports to exercise functions which on the face of them are within the proper remit of political organs of government. And he said, being a textualist, the court either has or has not jurisdiction to make the order. This is a purely legal question, quite independent of the minister's present intentions and of the possibility that the court might amend the order in the future. He then goes on to deal that all of the suggested foundations for jurisdiction to make an order of the kind in question are based on a misapprehension of the powers of the courts, and the Constitution doesn't attribute to any of the branches of government an overall or residual supervisory power over the others. It creates three equal powers, none of which is generally dominant. Equality of the powers can only operate in practice on the basis that there is each has a discrete remit. And since each of the powers, legislative, executive, and judicial, must fit harmoniously into the general constitutional order and modulation, as Henchy J. said, these include the power of the courts to ensure that legislation is consistent with the Constitution, the power of the legislature to remove a judge of the superior courts, and the power of the executive to tender binding advice to the President. That's the appointment of justice. And he goes on dealing with matters in that vein. Now, that's a very trenchant view. I've quoted it at length because it seems to me to raise the issue in a very black and white way regarding the situation where perhaps there is no defined separation of powers, and that the powers are identified as operating in parallel or overlapping. I don't claim to be an Indian constitutional lawyer, but the question I think that is worth asking is whether the orders and the judgments of the court in the 1980s, which we've discussed at such length, including consideration of the directives and the utilization of the directives, whether all of those together identify recognition of separation of powers, or whether, on the contrary, there is something different. And I think it raises the interesting question as to if there is no identification, no demarcation line, what limits can there be? So these are the issues I think we have to consider. It's, at one level, the issue is it sounds very arid, it sounds particularly conservative, right-wing, 18th century. But I rhetorically asked the question, is there another, perhaps more liberal interpretation of this? Are we, for example, dealing with what so many people in the democratic world talk about, accountability? Are we dealing with the need for each institution of the state to be properly accountable to the people? And are we dealing with a situation where a want of demarcation could potentially perhaps create difficulties regarding legitimacy? So that's a rather gloomy issue, a rather gloomy description. And I think it raises a further question, which I touched on at the beginning, which is the question of the rule of law. Because the separation of powers, classically speaking, was seen as one of the foundation stones of the rule of law. And that begs the question, if there is a want of delineation between the institutions, how can it be remedied? And to what extent can it be said that the rule of law gives rise to accountability? So I do not wish for a moment to be seen as saying one system is better than another. I recognize that every test must be contextual. I recognize that in the Irish situation there are questions which arise quite frequently, where we do much more than nudge the government. We certainly come close to putting pressure on the government to legislate. But when I first embarked on this wonderful challenge, I must say, for me, speaking personally as a judge from Ireland, one of the things that seemed to me most marked as a distinction was the question of separation of powers. And I look forward to what your comments are. Maybe I'm all wrong. It may be that we have to adopt an entirely contextual approach, and maybe on the other hand, it's an issue which all of you, in the fullness of time, when you're all judges, will be dealing with. Thanks very much.
Thank you for putting that issue across so well, and I'm really happy that you've made the links between rule of law, separation of powers, and I'm sure all of you haven't missed the context that this is not a federal constitution like we would want the Indian constitution to be, but this is a unitary constitution. And when the Indian Supreme Court justifies the lack of separation of powers in India, and it makes a reference to the fact that, oh, because we're not a federal constitution, the separation of powers don't need to be so strict. I think this was a very good example of saying that the idea of separation of powers is not only necessarily linked to written constitutions and federal constitutions, but it is an idea that is linked to rule of law and accountability. So I think this particular aspect has been brought out very well. I sincerely hope all of you will have comments to make on this, and maybe I can give you time to think about it. We can take a break and come back at 11:20 and continue this. Okay, thank you. Oh, they don't get tea now? No, but I'm sure they'll be resourceful enough to find other things to do.